Thank you very much, Chairperson. Good afternoon again, Advocate Batohi. I don't think I got a response on the issue that Honorable Ngala was asking you, just in terms of your knowledge as a jurist, how you handle classified information that's obtained in an illegal manner. Maybe you don't have to reference the IDAC case if you like, but I think the principle that we're trying to get to is that when somebody has obtained classified information they're not supposed to access, how then would you treat that? And then my final question, which is also a follow-up on the issues that they raised, you did say that we are not winning the war against organized crime, and I assume corruption, crime in general. Advocate Batohi, what is broken, right? Because I mean, there are people, a number of witnesses who have sat there, and everybody seems to really skirt around the issues. We'd really like to know what is broken. What do you think needs to be done to fix it? Thank you very much, Chair.
Chair, on the issue of illegally obtained evidence, if my memory serves me right, and I haven't been in a court prosecutor for a long time, there is a provision in our Criminal Procedure Act that allows for illegally obtained evidence to be admitted in court as evidence if it serves the interest of justice. And there might even be something in the Constitution, but I'm not sure. But that would be my response to that. On the
So
second,
the issue here with this, the case that is being staged up by IDAC, this is my view, and the NPA, is that the chain of custody and contamination of evidence, it's really problematic. That chain of custodies is tainted from inception. The NPA, National Prosecution Authority, cannot lawfully verify authenticity or integrity without breaching secrecy law. And the defense could challenge the entire prosecution as abuse of process and the fruit of poison tree. In South African jurisprudence, this principle is drawn from different cases, as versus Tandawan in 2008, Key versus Attorney General in 1996, where unlawfully obtained evidence can only be used if it does not undermine the integrity of the justice system. But here, the issue here is that the IDAC used classified intelligence leaked to this Fadiel Adams, who is unauthorized to handle classified information. This case would almost undermine justice in itself, almost certainly would undermine justice. So there's a lot of procedural missteps here that hasn't been clarified to this point from the IDAC, from Advocate Andrea Johnson, who testified last week. And this week we had the head of the director of National Public Prosecution, who also testify, as you have heard. The procedural missteps that I see here is the advised prosecution without ensuring that there's no way where they've been able to explain to us how they declassified this information or were able to have obtained authorization to use this information. They haven't actually been able. No, even the previous advocate has not been able to say how they declassify this information. So they used the affidavit and the materials that were leaked to this MP as a primary evidence for charges, and also did not notify the state security, South African security, or the Joint Standing Committee of Intelligence, the JSCI. Then the NDPP and IDAC would have acted beyond their powers. And I think they've acted beyond the power, this entity. It's a very problematic. because there is a very distinction that I would expected her for someone who is the head of them all to be able to run with it and explain this without any problem. Be this distinction between admissibility and the foundation. This is crucial. Admissibility and foundation is crucial in this case when we're talking about evidence obtained illegally, classified, admissibility, whether a court can allow this evidence obtained unlawful to be admissible in court. This one we know it's legally permissible under Section 35, subsection 5. Only in the interest of justice, if in the interest of justice prevail. All right, that's very important. Justice prevail, very important one. And then you have this foundation, whether such material can initiate prosecution or form a charge sheet, which they are. They form the charge sheet, these stuff. Now, they're not permissible unless lawfully obtained or regularized, or meaning declassified. Like I said, declassification, I was looking to see that she would actually explain how they declassify this information. Because we know from evidence from Lieutenant General Nkatam Kwanas that this information was initially, filed in different police stations, and they obtained legal advice, and they tried to communicate with this MP who did not do anything. And then this MP colluded with Senzom Kunu and then with IDAC, and then they cook up these charges using the same information. So they kind of like use that information, some of that information that they obtain illegally, to try and build up this case. Okay, this is actually, yeah, I mean, this is so embarrassing. My goodness. Yeah. So the issue is that this classified information from this MP, who is unauthorized MP, so to handle this information, they were used as a basis for charging Lieutenant General Dumisani Khumalo, who is actually a head of this crime intelligence, who uncovered these big five cartels. So unlawfully, they vow this thing. The state is that this one is unlawful, violates secrecy and prosecutorial procedure. But she could not explain this. I was expecting her to explain how they were able to explain to ensure that this thing is procedural fair, is procedural correct, because looking at how this information was obtained illegal, she could not understand that until she was helped again by another MP. So the Section 35, subsection 5 justification only applies to admissibility, not the foundation of prosecution. You need to understand this is very important here. That admissibility and the foundation. Here, this classified information formed a foundation of the charge sheet, folks. Yeah, that's what you need to understand here. So she actually bled critical distinction here. She conflicted illegally obtained evidence, which can sometimes be admitted, as I've explained, with classified material, which has its own separate secrecy and declassification procedure. Neither her nor her counterpart advocate. So she also spoke without any references. If you've listened to her, there was no reference to Constitution directly. Any NDPP really should immediately cite Section 35, subsection 5 when discussing illegal obtained evidence. Her saying, I think, it's somewhere in the Constitution. Yeah. it actually, yeah, it didn't build any confidence, and it sounded like she didn't know the law at all, really. And she also, crucially, what she also failed to mention in the submission is that the Protection of Information Act, uh, the that omission makes it seems like she either overlooked or downplayed the national security dimension of the case as well, because we're talking about the head of crime intelligence here. We're not talking about anybody here, which is a really serious oversight in front of the parliament. She also avoided naming oversight mechanism and the JSCI, the declassification process. Even those are mandatory steps. Like I said, they are mandatory steps, these declassification processes. If classified data was involved, it's been alleged. They said they've got more evidence. They've got evidence because it's classified data, that data that they shouldn't have known about it. You can't possibly use classified information to form the basis of a charge sheet. It really sounded like she was there on defending the indefensible, and without actually providing a solid legal grounding. Educate us, this is the public, which really gave me that impression of incompetency, of someone who's extremely incompetent. That has submission, just like the same as the other one, the advocate Andrea Johnson. It gave me that information. These people are so incompetent, absolutely incompetent. The way they provided this evidence, it gave me that impression. So the professional expectation for the NDPP, National Director of Public Prosecution, is that they should actually, you'd expect them to quote Section 35, subsection 5 with fluency, and also to be able to explain the difference between evidence admissibility and investigative legality, which are quite different distinctions, explained in a way that a 5-year-old could understand it, and outline the procedures for handling classified intelligence, and also be able to state these laws that are under the Protection of Information Act, the MISS. What are they? So failing to do so, especially in Parliament, on live recordings, suggests either lack of preparation, fear of self-incriminating, which I think that's what she was very deliberate in how she was so ambiguous in this state. She was really problematic.